Jonathan, thank you very much. Is this too loud? I have a loud voice. Let's drop this down a little bit. All right, what the introduction didn't tell you is that I spent 12 years with the U.S. Department of Labor Wage and Hour Division, first as an investigator and subsequently as the supervisor in the Dallas office. And so I have been doing wage and hour work on both sides, one side and then the other, since 1975. And I worked with Harry Weisbrod. Harry had represented APRO from starting in the either the 60s or 70s, and then when I joined him and ultimately bought him out, I took over. So I've been involved in this industry for a long time. Now, a couple of housekeeping things. Number one, I have a lot of material to cover, and I'm just hitting the highlights. It's very difficult to talk about this in less than an hour when I usually teach 4 and 8 hour seminars on it. And so when you fill out any kind of evaluation, you can write talks too fast, because I'm going to talk too fast. The other thing is, while I ordinarily like to take questions at the end, I have an incredibly tough airline connection. I may or may not get out of here, so I'm going to have to race out as soon as I'm done. So interrupt me with questions as we go along. Now, if it's something that would just take too long or whatever, I have business cards up here, and I am more than happy to, and I am more than happy to take calls from you. Shoot me an email, make a phone call, and I'll be happy to talk to you briefly without any, and as APRO members, you have access to my services anyway. So if you need to follow up on something, feel free to call. With that, let's start talking about the wage and hour law. That's my contact information, by the way, but as I say, I'm going to leave business cards up here. The Wage and Hour Law is the Fair Labor Standards Act of 1938. Stop and think about that for a minute. We are governed in our day-to-day business practices by a law from the Great Depression. The act establishes standards in 4 areas: minimum wage, overtime, child labor, and record keeping. The interaction with state law is whatever is hardest for you to do, that's what you got to do. So if whatever standard is of greater benefit to the employee, that's what you got to do. Anybody here have branches in California? No? Congratulations. California is an entirely different country when it comes to wage and hour standards. They are very, very tough. But the rule is, if there's a higher federal minimum, you pay the federal minimum. Higher state minimum, you pay the state minimum. Some states require daily overtime while the feds don't. If you're in one of those states, you got to pay daily overtime. Whatever standard is tougher. That's why you need to be familiar with the rules in every jurisdiction in which you operate. Okay, I'm going to stick mainly to the federal standards, but as I say, you need to be aware of your state as well. Now, I just picked some of the surrounding states to give you an illustration. The federal minimum is $725, unlikely to go up anytime soon unless the Democrats get the presidency and both houses of Congress. The minimum wage, it can't go up by regulation, it has to go up by statute, so they'd have to pass a bill. Kentucky, 7.25, Ohio, 8.55, West Virginia, 8.75, Illinois, 8.25, Indiana, Tennessee, Virginia, 7.25. So you're all over the map on minimum wage rates. Now, I'm not going to spend much time on minimum wage because I know you guys pay minimum wage or better, but I want to mention a couple of tricky things. The minimum wage is enforced on a work week basis. That is, you determine your 7-day work week, and the employee's got to walk away with at least the minimum wage in his pocket for that work week. Doesn't matter if he made a lot of money over the month or the year. Each work week stands alone. So, employees who are on commission, piece rate, etc., they may normally have a great earnings, but if they have a lousy week and fall below minimum, you got to bring them up to minimum. When it comes to deductions, the law talks about deductions that are made for the employer's benefit. So what are we talking about there? Cash shortages, Somebody wrecks one of your vehicles through their own fault and you'd like to recover the deductible, stuff like that. I hasten to add that in almost every state, you can make no such deduction from an employee's pay without their consent in writing. Now, the wage and hour law, the federal law, does not require employees' consent to make deductions, but it does put a limit on what you can deduct. And they can't even give you permission to violate this limit. Employees have no right to waive their rights under the wage and hour law. So, let's say you got a guy who makes $8.25 an hour and works 40 hours and he has a cash shortage of $100 and you'd like to get it back. Notice that the maximum deduction you can make is, oh, that's not what I wanted to do. The maximum deduction that you can make is 40 times the, I'm trying to find that laser point again. Oh, there it is. 40 times the difference between their rate and the minimum wage. So this guy makes 8.25, the minimum is 7.25. In a 40-hour week, he makes $40 over the minimum wage. You could not deduct more than $40 from his pay, even with his consent. You couldn't deduct the $40 without his consent, but you can't go below with or without. So what you'd have to do is take $40 in week 1, $40 in week 2, $20 in the third week to get your $100. Now, realistically, we all know it'll happen. The first time you make the deduction, he quits and you're out $60. But those are the limits. Now, in an overtime work week, I don't care how many hours he works, 50, 60, 70 hours, you can only recoup 40 times the difference between his rate and minimum wage. Overtime hours are sacred, and you may not deduct either the straight time or the half-time premium. Okay, certain deductions are not restricted by the Fair Labor Standards Act. Legal deductions, cash advances of salary, advance of unearned vacation, or arm's length purchases from the employer. Let's talk about cash advances for a second. You all know the drill, right? Guy comes to you in the middle of the month and says, geez, I'm short, they're gonna take my car, they're gonna kick me out of my apartment, I need a couple $100. And you, being good, kind people, advance it to him. The employee promptly quits, and you'd like to get your $200 back. Can you deduct that amount from his last paycheck? Under the federal law, yes, you can. You can dock him down to the minimum wage, you can dock him below the minimum wage, you can take him down to 0. Why? Because you already paid him the minimum wage when you gave him the advance. You have prepaid his minimum wage. When you make the deduction from his last check, you're just evening up the books. Again, however, get permission under state law to make this deduction, but if you've advanced wages, the notion is he's already been paid when he got the advance. Same basic principle is true of advances of unaccrued leave. Arm's length purchases simply means you don't make him buy something. Some of you here look old enough to remember that old Tennessee Ernie Ford song, 16 tons, I owe my soul to the company store. When you make them buy stuff from you, that's the company store. But if they freely want to purchase from you, let's say you're getting rid of some old equipment or furniture and you're going to sell it to somebody anyway, and the guy says, well, I'll buy it at such and such a price, and you'll take so much a week out of my pay, that's perfectly okay, as long as it was a peer-to-peer equal transaction. All right, as I said this before, but it's worth saying again. Most states are actually stricter than the feds on deductions. Even if you'd leave them with the minimum wage, state law requires their consent, and some states, like California, forbid certain deductions at all. So always be aware of where you are. All right, let's talk about overtime. Most people think that the reason we have overtime is to reward employees who have worked a long and burdensome work week, and that certainly is part of it. But that's not the most important reason. The most important reason is to spread employment. When was this law passed? 1938. What was going on? The Great Depression, right? Unemployment upwards at 25%. So Congress made a policy decision. If you have, say, 120 hours worth of work to do, Congress would rather see 3 employees do it in 40 hours each than 2 do it in 60. So they made it more expensive for you to work the two employees 60, hoping that you'll go out and hire the third. Well, of course, that's Depression era policy, and right now we're in a period where labor is actually pretty tough. So we could argue all day as to whether or not it ought to be the law, but it is the law. And the reason I make the point is that the way the law is enforced seems very arbitrary, seems very nitpicky, and there's a reason for that. They are trying to make it hard for you to work people overtime. They want it to be difficult and expensive so that you'll go hire somebody else. All right. Overtime, obviously, is time and a half of an employee's regular rate of pay for hours worked over 40 in a work week, and we'll talk about each component of that. I mentioned this with minimum wage. It's important with overtime. The measuring stick for compliance with almost everything in the wage and hour law is the work week. The work week is defined as a fixed and recurring period of 7 consecutive 24-hour days. It begins whenever you want it to, and it ends 168 hours later. You can designate any work week you want. Monday through Sunday, great. Thursday through Wednesday, fine. But whatever you designate, you have to live with. You can't slide people's work weeks around to minimize overtime. You have to live with the work week you select. The only time you can change it is if you're intending to make a permanent change. All right, now there's certain consequences of the work week basis of enforcement. The most important is no daily overtime is required. California requires time and a half after 8 in a day, double time after 12. Colorado requires daily overtime after 12. Alaska requires daily overtime, but the wage and hour law does not. So, if you have a Monday through Sunday work week, for example, and your employee works 12 hours to fill a bunch of back orders, and then Tuesday, Wednesday, Thursday works his standard 8, and on Friday at noon, you go to that employee and you say, Charlie, you've hit your 40 hours for the week, hit the clock, hit the door, I don't want to pay overtime, that is perfectly legal. You are free to move hours worked within the work week any way you take a notion. But once they've hit 40 in the work week, then any other hours worked in that week are overtime hours. Now, you may not average work weeks. If you pay, for example, every 2 weeks, and your schedule is expecting them to work 80 hours every 2 weeks, and somebody works 48 in week 1 and 32 in week 2, that's only 80 hours, but it's still 8 hours of overtime, because each work week stands alone. Okay, paid time off does not count toward overtime. So let's say you got a guy that has one of these Monday holidays and he's off with pay or his vacation or whatever, and he works Tuesday, Wednesday, Thursday, Friday, and Saturday. He's going to get paid for 48, but he's not due any overtime because he only worked 40. Now, any of you who have paid time off know how this works. Every time the employee comes to you and says, where's my overtime? I'm being paid for 48 hours. And many companies choose to treat paid time off, holiday, sick, vacation, as if it were worked. You're free to do that, but you don't have to. The law only requires overtime after 40 hours actually worked in the work week. And there's no such thing as comp time, at least in the private sector. You may have a brother-in-law that works for the city streets and sanitation department, and he gets comp time, but private sector cannot. Government can, private sector cannot. Now, when I say comp time, let's make clear. That example I gave earlier where the guy worked, yeah, he worked 4 hours over on Monday and got 4 hours off on Friday. That's not comp time. A lot of people call it comp time, but it's not. True comp time is where I actually work over 40 hours. You pay me my 40 and you put my overtime hours in a bank somewhere that I get to take off later with pay, sometimes even at time and a half in that bank. And as much as a lot of folks would like that, that is not legal under the Fair Labor Standards Act. All right. Now, everybody knows overtime is time and a half. Time and a half of what? Time and a half of the employee's regular rate of pay. That's what it says in the law. What do we mean by that term, regular rate? It's counterintuitive. It doesn't mean what the employee normally or regularly gets. has a clear legal definition. It's total remuneration for a particular work week divided by the total number of hours worked in the work week. In other words, regular rate equals total dollars divided by total hours. Now, what that means is that all compensation, base rate, bonuses, gain sharing, commission, piece rate, incentives, blah, 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 everything is part of the regular rate. In other words, you pay overtime on all compensation. I got in here at the tail end of the last presentation, and the speaker was talking about various bonus plans. And of course, I only got at the end. I don't know whether he's thought about this, but any kind of bonuses you're going to give non-exempt employees, you're going to pay overtime on those bonuses. So if you've got somebody that gets a base rate of $9 an hour plus a certain percentage of what he earns or what he delivers or what he rents, his overtime is not just time and a half of 9, it's time and a half of the total dollars divided by the total hours.
My accountant built a spreadsheet for that where you plugged in their hours, overtime hours, and their straight hours, and it gave you the real overtime, the bonus.
Yeah, excellent, excellent. And you would think that every payroll company, for those of y'all that don't do your own payroll, you'd think that, it's only been the law since 1938, that every one of them look at you like you're out of your mind when you're shaking your head. You obviously know. And yeah. And they look at you like you just landed from Mars or something. And so they got to call a bunch of people and bring a bunch of experts in and inevitably charge you more to comply. I will in just a moment. Yes, ma'am. All right. Now, this is your basic overtime calculation, right? Guy makes $10 an hour, works 50 hours. Payroll's going to show 40 times 10 is 400. 10 times 1.5 is 15. 10 overtime hours at 15, 150. Total 550. Anything wrong with that? No. That's kindergarten payroll. But there's a better way to think about overtime. When this guy got $15 an hour for overtime, what was that really? That's the same $10 an hour he got in the straight time hours plus an additional 1/2. So time and a half, 10 plus 5. And it's important to have that concept in mind because when we start talking about bonuses and things, that becomes significant. So here's the example that you asked me for. Let's say that same guy makes $10 an hour, works 50 hours, but gets a $100 bonus or $100 in commission or some kind of, he reaches a goal or a target and he gets this extra $100. You can't pay him time and a half, you can't pay him time and a half of $10 anymore because it's overtime on the regular rate, and when you gave him a bonus, you increased his regular rate. So his regular rate is 50 times 10 is 500 plus the $100 equals 600 divided by 50 hours worked equals $12 an hour. When you gave him a bonus, you changed his regular rate. So since the employee has received between his hourly rate and his bonus a regular rate of pay of $12 an hour for all 50 hours, you owe him the additional halftime. 12 divided by 2 equals 6. 6 times 10 is 60. Notice the difference. With no bonus, he makes $550. With the bonus, he would get $560. That $10 difference represents the overtime due on the bonus.
What if it's a monthly bonus?
All right. If it's a monthly bonus, you're supposed to allocate it back over the work weeks in the month in which it's earned. Now, that can get tricky, right? There's different ways to do it. Normally what I would suggest you do, assuming that you pay, since you probably pay weekly, you know how many hours the guy has worked in the month. So when the monthly bonus comes out, take his total hours worked in the month, straight time and overtime. Divide monthly bonus by monthly hours. That gives you the amount by which you have increased his average per hour for every hour in the month. So if he made a $500 bonus, say a $600 bonus for the month, and he worked 200 hours, take 6 divided by 200 is 3. Now you owe him $1.50, the additional halftime premium, for every overtime hour he worked in the month. And that's compliance because you figured the overtime hours week to week as you went along. So if he worked, say, 20 overtime hours during the month, you take that $1.50 times 20 is $30, and his bonus would be $600 plus 30 in overtime on the bonus. Yeah, it can get a little tricky.
Unless your state dictates that you pay it at a period that it's paid, right?
I'm sorry?
Unless the state dictates that you have to calculate it based on the period of which you pay.
Well, but yes, except that his question was, what happens with a state law that requires prompt payment? And the answer is, state laws typically require payment of wages when earned. A monthly bonus hasn't been earned until the month is completed, right? Because you base it on performance during the entire month. So even if you're paying the guy every week or twice a week or every bi-weekly or semi-monthly, he still hasn't earned the bonus until the month is complete. Then you must pay it promptly, usually on the next regular payday. Okay. I'm going over this quick, and obviously there's a lot of different types of bonuses that people pay. And so there's lots and lots of opportunity to screw this up. But the fundamental principle is that you have to allocate earnings to work weeks and compute overtime on total compensation per work week.
Now, is that true for discretionary and non-discretionary?
All right, well, you bring up one of the exceptions that I really didn't have time to talk about, but I'll mention it since you brought it up. Is it hot in here to you? It's sure hot to me. Of course, that may be my advanced girth that's contributing to that. Well, thank you. There are a few exceptions, things upon which you do not have to pay overtime. And the most prominent of these is discretionary bonuses. So a discretionary bonus is a bonus where both the fact that there's even going to be a bonus as well as the amount of the bonus, these things are only determined at or near the end of the period in question. In other words, it's the end of the year. I'm the boss, I look at the books, we've had a great year. We've had such a good year, in fact, that I want to share the wealth with my employees, so I give everybody $1,000. Notice that both the fact that there was even going to be a bonus, as well as how much it would be, I only decided that at the end of the year. That's a true discretionary bonus. But if I go to you, Trent, at the beginning of the year and I say, work hard, because if we have a good year, you'll get a bonus, that's no longer discretionary. Whenever you hold the bonus out to the employee as an incentive to work, it's not discretionary. If you set up a formula, like a nickel a widget for every widget produced, or if you set up a target, like if we increase market share by 10%, or if we reduce the delinquencies below 5%, or whatever it may be, you'll get a bonus. Those are non-discretionary because you've triggered it. A true discretionary bonus is like manna from heaven. It just falls on the employee.
Like if Trent worked paid cycle at a store 25 miles away for us, we needed him there, and we said, boy, that sure was kind of him. I think I'm going to give him a $100 discretionary bonus.
That would be truly discretionary. Or if, you sometimes see these management textbooks where they talk about management by walking around. So you walk around, you see some guy doing a really good job. You say, okay, buddy, you get $100 this week. That's discretionary. But if you say every time you rent a particular washing machine from Whirlpool, you get an extra $10, that's a spiff or push money or whatever you want to call it. That's part of the regular rate. So it has to be truly discretionary. Okay. Even employees whom you choose to pay totally by commission or piece rate still have to be paid overtime. Let's say you got a guy who works 50 hours and he earns $500 in commissions. His regular rate is what? Total dollars, 500 divided by total hours, 50 equals $10 an hour. That commission payment of $500 paid him straight time for all 50 hours at $10. What do you owe him? The additional halftime premium for the 10 overtime hours. So, whoops, I keep hitting those buttons. So 10 over 2 is 5. 5 times 10 overtime hours is $50. So he earned $500 in commission, and he gets another $50 in overtime. Now there is, and I don't have time to go into it, there is an overtime exemption for certain employees who are paid primarily by commissions if they work in retail establishment. That's called FLSA Section 7I, 7 parentheses, lowercase I, close parentheses. If I know some RTO stores actually pay their people primarily on commission, or they'll pay like assistant managers who don't qualify for exemption as salaried managers. They'll pay them primarily on commission. And if you're in a state that recognizes this as well, and they earn a substantial amount of money, you can exempt them from overtime. I don't have time to explain it, but again, you guys can contact me if that interests you, and I'll talk to you about it. All right. Well, now what did I do? Okay. All right. And that's all I'm going to say about overtime right now. Obviously, we could do a lot more talking about calculations, but those are the fundamental principles. Overtime paid after 40 hours worked in a single work week. Overtime based on total compensation, not on just on base rate. All right, let's talk a little bit about recording, counting, and paying for hours worked. According to the regulations, this is what you're supposed to keep on every employee. Normal business information, name, rate, gross, net, Social Security. Here's the most important thing for our purposes. You must keep accurate daily and weekly record of hours worked. Time and payroll record. My fingers are just too fat for this. Time and payroll records kept 3 years, time cards, time sheets 2 years, and this is important as well. There is no specified form that you must observe for maintaining time. You can do it any way you want. You can have them fill out handheld time sheets or time cards. That's not best practice, but you can. You can use the old mechanical time cards. You can use electronic timekeeping, point of sale systems or swipe or thumbprint systems. Any system you want, as long as it results in an accurate record of the hours worked each day and each week by each of your employees. Now, you have to pay for hours worked, not punched. So let's say you got some guys that are ex-military, they're used to getting up at dark 30, and your store opens at 8 o'clock, and these guys show up at 7, 7:15, 7:30 every morning. And they don't do any work. Put this down any further, it'll be on my pants leg. They don't do any work. They just sit around and BS, drink coffee, whatever. They punch in when they come in, but they don't start to work till 8 o'clock. Then one of them gets mad because you fired him. And he goes down to the labor department office and he says, they made me come in at 7:30 every morning and start to work, but they only paid me from 8 o'clock. Investigator comes out, pulls your time cards, time records, takes a look, and by golly, there it is, punched in every day, 7:15, 7:20, 7:30, only paid till 8 o'clock. Now you're arguing against your own records. Not a good place to be. It's a very good idea to discourage what we call long punching. Substantial periods of time recorded but not paid cast doubt on the validity of the employee's timekeeping system. And if your time records seem inaccurate or incomplete to the government, they will ignore them. And how many hours do people work? They work as many hours as they've got the guts to tell the investigator. Without accurate timekeeping, you are at the mercy of your least honest employees. So it is every supervisor's duty, just as much as it is to rent stuff, it's every supervisor's duty to monitor the hours worked by his or her subordinates. It's, just telling them to punch in and out and then never looking at it again will not work out well. You need to evaluate store managers based on how well they cover these details as well as how well they run the store. All right. Now, so far I've talked about paying minimum wage for all hours worked. I've talked about paying overtime for hours worked over 40, and I've talked about keeping an accurate record of hours worked. What do I mean by hours worked? What time has to be recorded and paid for? Hours worked under the law includes all time you require the employee to be on your premises, all time the employee is required to be at a work site, and here's the broad one, all time spent in activities which are of benefit to the employer, whether onerous or burdensome or not. You can hire employees to do nothing at all. I know what you're thinking. We got a lot of those back at the store. Now, you could hire somebody whose job it is to sleep in the store at night to keep people from breaking in. You don't want him to have anything to do, but he's still working because his activities benefit you. So, management has the power to set employees' schedules, to move them around, to work anytime you want them to work. You want them to work Christmas Eve, they got to work Christmas Eve. But with that power comes responsibility. You remember Spider-Man, with great power comes great responsibility? You have the complete responsibility for recording and paying for time worked. For example, if you tell your employees no unauthorized overtime and they work unauthorized overtime, you may discipline them, but you still have to pay them the overtime. It was your job as the employer to see that they either didn't work it, or if they worked it, that it was recorded and paid for. Sometimes, I'm afraid, this means you must discipline your best employees, the ones that come in early, stay late, work through lunch. They cannot volunteer time, even if they want to. I don't know how many times I either, as an investigator or supervisor, ran into what I will call Marge. Marge is the office worker who is the most conscientious employee anyone ever had. She comes in early because she wants to organize everything so she's ready to go the second that the phone starts ringing. She sits at her desk at lunch so that she can answer the phone if it rings. She sticks around afterwards because she can't stand the idea of leaving a messy desk. And when you tell her, Marge, you're supposed to record that time. Oh, no, that's my time. Well, everything rocks along until a wage hour investigator comes in and he talks to Marge. And Marge, of course, is super honest. So when you interview her, oh yes, I usually come in 15, 20 minutes early and get the work started. And yeah, I sit at my desk and answer the phone if it rings. It doesn't always ring, but I do. And I usually stick around an extra half an hour, but I volunteer that. They don't make me do it. The investigators writing all that down, and then okay, Marge, here, is this accurate? Sign it. And then they compute a bunch of money for Marge. The fact that the employee may want to work like that, you are the boss. It's your responsibility to control that. Okay, now, let's talk about, there's a million hours work questions, but let's talk about meal breaks. They are not required by the law. Many states do require breaks and lunches. They'll require a minimum of half an hour lunch somewhere in the middle of the shift. The feds don't, but what the feds do is tell you how to pay for it if it's given. And the basic rule is that you do not have to pay for employees' meal breaks, provided that, number one, they're long enough for the employee to consume a meal, typically 30 minutes. Number two, uninterrupted. And number three, relieved from duty. And uninterrupted and relieved from duty are not the same thing. If I tell my secretary to sit at her desk during her lunch hour and answer the phone if it rings, she's working through lunch even if it doesn't ring, because she has not been relieved from duty. Now, the wage and hour law does not say they have to be free to leave the store. Some states do, notably California, that they have to be free. But you can't, in good practice, you can't have them working through lunch, and you can't have them stay at their workstation. They need to be in the back in a break room or something. You don't want any basis for them to claim they're working through lunch. Okay. Breaks. Not required, but if given, must be treated as working time. Again, some states require it. So let's say you got the typical 8 to 4:30, half an hour lunch, 2 15-minute breaks. How many hours is that? That's 8 hours of work. You can deduct the half-hour lunch, but you can't deduct the 2 15-minute breaks. So I've had situations, I once had a city government reach out to me because they had for years been on a schedule like that where they gave the employees an hour lunch and no breaks. Well, this was down in Texas. In the summer it gets pretty hot. They didn't need the hour for lunch, but they sure liked to have an afternoon break. So the city unilaterally changed from an hour unpaid lunch to a half-hour unpaid lunch and 2 15-minute unpaid breaks. Well, they just added a half an hour of work time every day because the breaks should have been compensated. So if you give breaks, you need to pay for them. All right, travel time. There's a lot of different travel scenarios. Home to work travel is not compensable. So let's say you own multiple stores and you have an employee who leaves his home in the morning and drives to a store where he normally works. That's not compensable time. And then he drives home at the end of the day. That's not compensable time. If you tell him to drive to another store, you gave an example earlier, you got another store 20 miles away and they're short, so you tell him to, that's not hours worked. It's still commuting time. But let's suppose in the course of his duties, he goes to store 1 from home and then goes from 1 to 2, from 2 to 3, and then drives home from 3 in the afternoon. The time from home to 1 and from 3 to home is not compensable. The time between stores is. So travel time during the day is compensable time. Now, it's obviously true for delivery people or account managers, but and this is true, by the way, even if you give him a company vehicle. So you allow a particular account manager to take a truck home and he commutes in that truck. The fact that that truck is also used for business, and maybe you even tell him, look, on your way in, pick up a big screen at this customer. Driving from home to the first job site of the day, even in the employer's vehicle, is not compensable. Now, once he gets to that first house and picks up the big screen, now he's working. Now he's on the clock. Okay, travel during the day, I talked about that. All right, how is this law enforced? It's typically by investigation. And most investigations by the U.S. Department of Labor, Wage and Hour Division are complaint investigations, usually from a disgruntled employee, former or current, sometimes from competitors. There are 4 parts. An opening conference, they go back over 2 years of records, they interview employees, and they hold a final conference where they give the results. Now, if you cannot resolve a case where you just don't think that what you're doing was wrong, or you don't like the back wages they computed, usually they'll give you a second level conference with a boss. After that, it's up to the government. They're not the IRS. They can't seize your bank account. They can't put a lock on the door. But they can go to U.S. District Court and file a lawsuit. And folks, you don't want to be in a lawsuit against the government. You pay your lawyer by the hour. The government's got a bunch of lawyers that collect a paycheck every 2 weeks, whether they sue or not. So for all practical purposes, they have unlimited legal resources. If they sue you, they will not only sue you for back wages for 2 years, they will also ask for what are called liquidated damages. That's damages equal to the back wages. So basically you pay double back wages, and if they can prove the violation was what they call willful, they can go for a 3rd year on the statute of limitations, as well as getting an injunction from the court making future violations contempt. Now, what happens if your employees don't go to the feds? They go right to a lawyer. They can file their own lawsuit for back wages, liquidated damages, the 3-year statute if it's willful, and their attorney fees. So if you get sued by an employee, or even worse, in a collective action by multiple employees, and lose, you pay your lawyer to defend you, you pay their lawyer. The lawyers always get paid. Is this a great country or what? Now, any questions? Those are what we call a brief overview of the rules for non-exempt employees. That is, who are not exempt from the overtime requirements. Let me talk real briefly about exempt employees. There's about 40 exemptions in the Fair Labor Standards Act, but there's only one that's applicable to potentially at least to every type of business, and that's the so-called white-collar exemption for executives, administrative, professional employees, and outside salespeople. These are folks who are typically salaried with no additional compensation for overtime. Exemption requires 2 things, however: salary and meeting certain duties tests. That's why you can't put the janitor on salary and call him the president and exempt him from overtime. He may be salaried, but he doesn't meet the duties test. Most states with overtime laws track the federal rules. The amount of money required at this point is still $455 a week, where it's been since 2004. There's a proposed reg. Remember, the Obama administration tried to raise it to $913 a week. That was overturned by the courts. The Trump administration is now proposing $679 a week. That has yet to be adopted. So it's $455 till you hear otherwise. General rule on salary number 1. And with a few exceptions, an exempt employee must receive his full salary for any week in which he performs any work at all, without regard to days or hours worked. Number 2, exempt employees need not be paid for any work week in which they perform no work at all. If you deduct for absences, if an employee is absent because of the employer, lack of work or bad weather or there was a fire or whatever, they have to be paid their full salary unless they miss the entire work week. However, if the employee causes the absence for personal reasons, a deduction from pay may be made when an exempt employee is absent from work for 1 or more full days for personal reasons. If it's an absence due to illness, the full day rule applies if you have a bona fide sick leave plan and they either haven't qualified or have exhausted their leave. So that's basically the circumstances under which you can dock salaried exempt employees. Now, every exempt category has a primary duty test. When you hear the word primary duty, it means their most important function. The primary duty of an executive is management. Management of the enterprise as a whole or of a customarily recognized department or subdivision. So, I have 6 stores. I have a manager at each one. Each one of those can qualify because they are managing a customarily recognized department or subdivision. Now, in addition, they have to supervise 2 full-time subordinates or their equivalent in part-timers. So that's 80 hours worth of subordinates. If you had a store with 1 manager, 1 assistant manager, and 2 account managers, only the manager can be exempt. The assistant manager can't because you can't share employees. They've got to have direct management of at least 2 people. They have to have the power to hire and fire, or at least recommend hiring, firing, promotion, or other change of status. That's management. Very simple. It's usually pretty easy to spot. The next test is what's called, or category, is the administrative category. Their primary duty must be office or non-manual work. Administrative employees are not account managers because they got to schlep stuff around. Directly related to management of the business, management or general business operation of the employer. Their primary duty must include the exercise of discretion and independent judgment with respect to matters of significance. In other words, we're talking about high-level decision-making staff employees. You're not going to have very many of those in a rent-to-own business, except in the main office. Routine secretarial, clerical duties are not exempt. Bookkeeping functions such as accounts payable, receivable, payroll are not exempt. In a typical RTO employer, only jobs like HR manager, safety director, etc. are likely to be exempt. Professionals, you got to be a huge company to have a professional. You have to have a CPA controller or a general counsel. It's basically learned professionals, creative artists, teachers in educational institutions, and high-level computer people, programmers and analysts, and outside sales. If your primary duty is making sales or obtaining contracts for services away from the place of business, you can be exempt as an outside salesperson. While telephone sales are not outside sales, inside work incidental to and in conjunction with outside sales work is exempt. Who are we talking about here? Willie Loman. I remember high school English. You had to read Death of a Salesman, right? Willie Loman out there with his sample cases on a shoe shine and a smile. That's who they're talking about. People that go out and call on customers and try to sell them stuff. So, and that, I believe, is that. Oh, and no compensation or salary of any kind is required for outside salespeople. You can work 50 weeks a year, 100 hours a week, never make a nickel, you're still exempt. All right, that's it. Thank you very much. I have left, as I told you, I got to run to make a plane. I have left business cards up here. I assume the presentation will be on the website.
I believe so.
And it's got my contact information on it as well. So anybody that takes one of my classes, I let them call me for a little bit of free advice. And since you're APRO members, you have that right anyway. So, thank you very much.
Be sure to go into the app and give feedback.